Well, it looks like we might have our very first case of over-fortification. Viva Frei, Montreal litigator turned YouTuber, and we have a very interesting case coming out of Michigan as relates to the elections of 2020. Now, under the new rules at YouTube, there are certain things that content creators are and are not allowed to say as relates to the 2020 elections. I have no intention of saying any of the things you are not allowed to say as relates to the 2020 elections. I have no intention of saying them because
I have no intention of saying them.
I have done tons of vlogs and live streams with Robert Barnes where we discussed all of these issues while we were still able to discuss them. I've got nothing more to add. I just want to read a finely drafted judgment coming out of Michigan. But before I walk through this judgment, the standard disclaimer: Joe Biden is the lawfully elected president of the United States. Nothing in this video seeks to undermine or contradict that fact. Is that good enough, guys? All right, I am obviously joking. If I were not joking, I would blink 3 times. But before we break down this decision, which is actually relatively well drafted and easy to understand, I want to just point out the fact that I don't seem to see many other mainstream media outlets reporting on this decision. I came across this decision through a Breitbart article, and because I am equally cynical to all mainstream media, I did read that Breitbart article with a certain degree of cynicism, knowing its partisan leanings. Partisan leanings which are obvious from the headline itself and their choice in photographs. Michigan court. Michigan's Secretary of State's absentee ballot order broke law, vindicating Trump claim. So you have to read this headline and be able to identify what is a fact and what is an opinion. The fact that the Secretary of State's absentee ballot orders broke the law is a matter of fact. The fact that it vindicated a Trump claim is a matter of opinion. It may be an opinion that can be supported by the decision itself, but it is nonetheless an opinion, and one has to be careful of headlines that fuse fact and opinion together. Another indicator of political bias is always the choice of photo used. When they choose an unflattering photograph to depict the person about whom they are talking, you know there's some politics at play. And although the unflattering nature of the picture might also be a matter of opinion, I tend to think some opinions are more justifiable than others, and I do not find this picture to be a particularly
Flattering picture.
I have no doubt there were more flattering pictures out there that Breitbart could have chosen to use, but they chose to use this one for editorial reasons. It is up to them. It is a detail. Let's get into the judgment. State of Michigan Court of Claims, Robert Gonetsky, Count of Allegan Clerk, individually and in his official capacity, and Michigan Republican Party, plaintiffs versus Jocelyn Benson in her official capacity and Jonathan Brader, Director of Elections, in his official capacity, defendants. Opinion and order granting summary disposition in part to plaintiffs and granting summary disposition in part to defendants. Honorable Christopher M. Murray. Now, you will see from the first paragraph of this judgment that there is a lot going on in this judgment from a procedural perspective. There are a number of aspects to the order. We're not going to get into it because it would be a total distraction from the only point that we care about. At the very least, the only thing we care about for the purposes of this vlog, which focuses only on the illegal nature of the guidance given by the Secretary of State as relates to counting absentee ballots. Before the court is defendants' January 20, 2021 motion for summary disposition filed pursuant to MCR 2.116 C4 and C8, as well as plaintiffs' February 3, 2021 cross motion for summary disposition filed pursuant to MCR 2.116 C8. Plaintiffs' cross motion will be granted in part with respect to count 2 of the amended complaint because the challenged signature matching standards were issued in violation of the Administrative Procedures Act. As a result of the grant of summary disposition in plaintiffs' favor on count 2, count 1 of the amended complaint will be dismissed without prejudice. In addition, defendants' motion for summary disposition will be granted in part with respect to counts 3 and 4 of the amended complaint. We will not be getting into counts 3 and 4 because it will only be a procedural distraction from the question at issue. We are only going to focus on count 2, and the judge goes on to describe the background at issue here. Background. The issues raised implicate signature matching requirements for absent voter ballot applications and absent voter ballot return envelopes contained in the state's election law. MCL 168.759 and MCL 168.761 require voters to sign applications for absent voter ballots in order to receive a ballot. In addition, the state's election laws require voters who choose to vote by absent voter ballot to sign their absent voter ballot return envelopes in order to have their ballots counted. MCL 168.764A. The signatures on the applications and the return envelopes are compared against signatures in the qualified voter file or those that appear on the, quote, master registration card in order to determine whether the signatures match. Signatures on applications or return envelopes that do not, quote, agree sufficiently, end quote, with those on file are to be rejected. As of October 6, 2020, MCL 168.7612 was amended by 2020 PA 177 to give notice to voters whose signatures do not, quote, agree sufficiently, end quote, with those on file that their absent absent voter ballot application has been rejected. The purpose of the notice is to give voters the opportunity to correct inaccuracies with absent voter ballot signatures. So that is the procedure for absent voting as was law as amended in 2020. What happens next? Well, the Secretary of State gives some guidance which, according to this judge,
deviate from the letter of the law.
And how did this guidance deviate from the letter of the law? Well, it created a presumption of validity of the signature on the absent voter ballot application and on the absent ballot. On the day PA 177 became effective, defendant Jocelyn Benson issued what defendants refer to as, quote, guidance, end quote, for local clerks who are charged with inspecting signatures on absent voter ballot applications and ballots. The document, which was entitled, quote, Absent Voter Ballot Processing, Signature Verification, and Voter Notification Standards, end quote, largely mirrored guidance defendant Benson had previously issued. This guidance regarding signature verification forms the heart of the issues in the present case, and it requires additional examination. The judgment then goes on to explain in further detail how this guidance created a presumption of validity of signatures on absent ballots. The stated purpose of the at-issue document was to, quote, provide standards, end quote, for reviewing signatures, verifying signatures, and curing missing or mismatched signatures. Under a heading entitled, quote, Procedures for Signature Verification, end quote, the document stated that signature review, quote, begins with the presumption that, end quote, the signature on an absent voter ballot application or envelope is valid. Further, the form instructs clerks to, if there are, quote, any redeeming qualities in the absent voter application or return envelope signature as compared to the signature on file, treat the signature as valid, end quote. Quote, redeeming qualities, end quote, are described as including but not being limited to, quote, similar distinctive flourishes, end quote, and, quote, more matching features than non-matching features, end quote. Signatures, quote, should be considered questionable, end quote, the guidance explained, only if they differ, quote, in multiple significant and obvious respects from the signature on file, end quote. Quote, whenever possible, end quote, election officials were to resolve, quote, slight dissimilarities, end quote, in favor of finding that the voter's signature was valid. The section on signature verification procedures goes on to repeat the notion that, quote, clerks should presume that a voter's absent voter application or envelope signature is his or her genuine signature, and there are several acceptable reasons that they may have an apparent mismatch, end quote. So you get the idea. That was a lot of reading, but I think it's necessary because I don't want anyone accusing me of misrepresenting the questions at issue or how the judge described it. The argument is that the Secretary of State, in her guidance on how to apply the law, created a presumption of validity of the signature that itself did not exist under the law, and therefore her guidance was illegal. It was illegal in that her guidance materially modified the law without going through the standard legislative process as required under law. And recall, this is by no means the first time this type of argument came up in the context of the 2020 elections. There was always the discussion of the separation of powers between the legislative branch, the executive branch, and the judicial branch. And the question of whether or not the election laws could be materially modified by the judicial branch actually came up in one of the Pennsylvania lawsuits, which made its way all the way up to the Supreme Court in a petition for cert that the SCOTUS subsequently rejected. The question in that case was whether or not the judicial branch could modify the election laws by extending the delays for receiving ballots. The Supreme Court decided not to hear the case on the basis of mootness, but Justice Clarence Thomas had one heck of a blistering dissent that I analyzed in one of my vlogs. Go check that out. That vlog was a good one if I say so myself. In this Michigan judgment, it's not a question of whether or not the judicial branch modified the election laws. It's a question of whether or not the Secretary of State, through her guidance, unlawfully modified the election laws, and the court came to the conclusion that yes, she did. Plaintiff Robert Ganeski is the Allegan County clerk. He, along with plaintiff Michigan Republican Party, filed a complaint alleging that defendant Benson's October 6, 2020 guidance is unlawful. The December 30, 2020 amended complaint alleges that the presumption in favor of finding valid signatures is unlawful, as is the directive to find, quote, any redeeming qualities, end quote, for signatures. They contend that the presumption contained in the guidance issued by defendant Benson will allow invalid votes to be counted. Plaintiff Ganeski has not, however, alleged that this guidance caused him to accept a signature that he believed was invalid. Legal translation, he is alleging that the guidance was unlawful, but not that it had any impact on the outcome, which is very reminiscent of what Justice Clarence Thomas said in his blistering dissent. It's sort of the way of facilitating the evidence in that they don't have to show that it had an impact on the election, they are just arguing that it was unlawful guidance in the first place. And that will presumably allow me to make a video on the subject and have this video remain monetized. Count 2 of the amended complaint alleges that defendant Benson's guidance was a, quote, rule, end quote, as defined by the Administrative Procedures Act, APA, that was issued without compliance with the APA APA. Plaintiffs allege that the guidance is in fact a rule because it is generally applicable and requires local election officials to apply a mandatory presumption of validity to signatures. Plaintiffs ask the court to declare that the quote rule end quote is invalid. Moving on, and as one could have probably predicted, the defendant raised the argument that there is no longer any controversy, the election happened, there's nothing to decide, they should just dismiss this lawsuit altogether. But the court dismisses that argument, and for good reason. The court also rejects defendant's contention that there is no actual controversy. As noted, plaintiffs seek declaratory relief. MCR 2.605A1 requires that there be, quote, a case of actual controversy, end quote, for the issuance of declaratory relief. Quote, in general, actual controversy exists where a declaratory judgment or decree is necessary to guide a plaintiff's future conduct in order to preserve his legal rights, end quote. Here, plaintiffs, particularly plaintiff Ganetsky, who is a local clerk subject to the guidance at issue, sought a declaration regarding whether he is and will continue to be subject to guidance that by all accounts remains in effect at this time. This clearly presents an actual controversy that is appropriate for declaratory relief. Legal translation, the impugned guidance is still in effect, so there still is an actual controversy, but I do wonder what would have happened if they had terminated that guidance immediately after the 2020 election. Would the court then have been able to declare that there is no controversy because the guidance at issue is no longer in effect? Who knows, but the guidance is still in effect, so the court can render its decision. The court can render its decision as relates to the potential illegal nature of that guidance without any concern because nobody is alleging it would have made a difference in the 2020 elections. The judgment then goes on to explain the powers of the Secretary of State, who has powers to issue guidance as to how the laws are to be applied, but does not have the power to change those laws. As for whether the guidance or directive at issue is a, quote, rule subject to the APA, the court must look beyond the labels used by the agency and make an independent determination of whether the action taken by the agency was permissible or whether it was an impermissible rule that evaded the APA's requirement. In other words, the court, quote, must review the actual action undertaken by the directive to see whether the policy being implemented has the effect of being a rule. Second, the cited statutory authority requires defendant Benson to issue instructions that are, quote, in accordance with the laws of this state, end quote. Here, it is not apparent that the mandatory presumption of signature validity is, quote, in accordance with the laws of this state, end quote. To that end, nowhere in this state's election law has the legislature indicated that signatures are to be presumed valid, nor did the legislature require that signatures are to be accepted as long as there are any redeeming qualities in the application or return envelope signature as compared with the signature on file. Policy determinations like the one at issue, which places a thumb on the scale in favor of a signature's validity, should be made pursuant to properly promulgated rules under the APA or by the legislature. And the court goes on to summarily conclude as follows. In sum, the standards issued by defendant Benson on October 6, 2020 with respect to signature matching requirements amounted to a, quote, rule, end quote, that should have been promulgated in accordance with the APA. And absent compliance with the APA, the, quote, rule, end quote, is invalid. That is the decision. Digest it the way you choose. There are going to be some who are just going to totally ignore it. Others who become aware of it are just going to write it off. It's just one judge in Michigan. It wouldn't have changed the outcome. We'll see what the Court of Appeal has to say, etc., etc., etc. Bottom line, the decision is out there. We will see if this goes to appeal. We will see if they just change the guidelines for the next election or if they pass it through the proper legislative channels in order to have it applied lawfully. To be determined and to be further discussed with Robert Barnes during our next live streams. And with all that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm. Go! If you want to support the channel, you know how. All of the support links are in the pinned comment. Robert Barnes and I have weekly live streams every Sunday. We have started doing weekly interviews every Wednesday. We've had Dave Rubin on, Mike Cernovich. We are going to have Gad Sad on next week. We're going to have Robert Gruler on tonight from the R&R Law Group, so tune in Wednesdays for some awesome live streams. But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and because I know all of you want to see Winston, he is right there on my jacket, sleeping like a cute little baby. And now you know your vlog. Peace out. Yeah.